Thank you everyone for joining us today for this webinar. My name is Sarah Bruin from IISD. I know for many of you this is a summer holiday period, so we're especially grateful to have you here with us today. I'll just take this opportunity to again remind everyone that we do have translation or interpretation rather to both Spanish and French available today, so please be sure to select the channel that you'd prefer. So we're all here today to discuss the proposed multilateral framework on investment facilitation and how it might interact with the web of almost 3,000 existing international investment agreements. But before we get started with the webinar, I'd like to do a couple of quick anonymized polls so that we can get a bit of a sense of who is with us here today and how familiar we all are with today's topic. So if you'll just join me, I'm going to launch our first poll. I'd like to know what type of organization you're joining us from, and then which part of the world you're joining us from. So if you could just quickly give us your response, would be really great for everyone to have a bit of a sense of who's who and who's coming from where. So it is an anonymous poll. There won't be a test at the end, I promise. Okay, so we've got about 2/3 of people have voted. Okay, I'm going to end the poll and share the results here. So, okay, this is interesting. So we've got about, well, over half of you joining us from governments, and then a sort of even split between academia, international organizations, a few NGO and private sector. And in terms of regions, we're sort of, again, a relatively even split between Africa and Europe, with the rest distributed. I think we've probably got a bit of a tricky time zone for Oceania, which is my personal home region. So thank you very much. I'll just do one other quick poll before we get underway. And this is to get a sense of how much you already know about the topics that we're going to discuss. And as I said, this is strictly anonymous. If you say you're very familiar, we won't be calling on you, so don't worry. But we'd like to know how familiar you already are with the process of developing the multilateral framework for investment facilitation. And then secondly, how familiar you feel you are with the actual content of the current draft text. Okay, so I'll give you a few minutes a few seconds rather to get your votes in. So let me just share these results. Okay, so the majority of people feel slightly familiar on both counts. So slightly familiar with the process, slightly familiar with the draft text. So that's good. I think it's good. We've got quite a few people also not at all familiar, and then a few people on the moderate side. So we've got a relatively even split here. So let me just get rid of that. So thank you very much for participating in that. I think it's interesting and useful for us all to have a sense of who's in the room. And it's useful for us to know as we start our discussions today. Investment facilitation has developed an increasingly high profile amongst policymakers, academics, and international organizations over the past 5 years. And it's now become a subject of a joint statement initiative on a proposed multilateral framework for investment facilitation among a group of WTO members. This group has spent more than 2 years now engaged in structured discussions to identify and develop the elements of a framework for facilitating foreign direct investments. And in December 2019, the group of WTO members had agreed to move to negotiations early this year. A streamlined text was circulated in January, and an informal consolidated text was circulated in April with subsequent revisions, the most recent from July. Due to COVID-19, the planned negotiations were suspended, and the group of WTO members involved in the initiative is now looking to start negotiations next month in September. But despite all of this momentum, some key questions remain unanswered. One key question of particular interest and concern to investment negotiators is the scope and coverage of a potential multilateral framework for investment facilitation and how it would interact with the wide web of existing international investment agreements. So this webinar is focused on this key question, and it aims at generating a greater understanding of the technical issues at play in the relationship between the proposed framework and the current international investment regime. For those investment negotiators with us who plan to attend next month's IISD virtual forum for developing country investment negotiators, this webinar will provide important technical background to the broader discussions that we'll have at the forum about whether a potential multilateral framework could contribute to achieving sustainable development objectives. So to discuss these issues, we're joined first by IISD's Natalie Bernasconi, who is the Senior Director of the Economic Law and Policy Program, and Soledad Leal Campos, a Senior Policy Advisor specializing in trade law. Soledad will explain a little bit about the history of the structured discussions on investment facilitation at the WTO, and will provide an overview of the text as it stands today. Natalie will then walk us through some of the key areas where the multilateral framework would overlap with investment treaty obligations and what this interaction could mean. We're then very pleased to have with us Chantal Onanaiwu, Trade Policy and Legal Specialist with the Caribbean Community, or CARICOM, and Hamid El-Kadi, an Investment Policy Advisor at the United Nations Conference on Trade and Development. Chantal and Hamid will then share with us their insights and reflections, particularly on the critical questions of what all of this means for developing countries and their sustainable development objectives. Please feel free to share your questions with us at any time at all during the session in the chat box. Feel free to write in English, Spanish or French as you prefer, and we will provide an opportunity towards the end of our session for our speakers to answer your questions. So thank you. Without any further ado, I will hand the floor to Soledad.
Many thanks, Sarah, for your introductory comments. Good morning or good afternoon to you all. I'm very pleased to make a presentation in our webinar today on the Multilateral Framework on Investment Facilitation, also known by its acronyms in English, MFIF. The purpose of my intervention is threefold. First, to share some background information and a brief overview on the work on investment facilitation that has been carried out by a group of WTO members in recent years. Second, to give a brief overview on the evolution of the structured discussions on investment facilitation, which have led to the informal consolidated text that Sarah just referred to, and which is being discussed by participating members in the negotiations. And third, to explain some of the main draft provisions contained in such text, and to share some questions arising from those provisions. As you may see on the screen, I have structured my presentation into three sections. The first one will give a brief overview on the joint statement initiative on investment facilitation. The second one of the evolution of the structured discussions. And the third one of the informal consolidated text. So now let's move to the presentation. And as Sarah mentioned, the subject of investment facilitation has taken a prominent place within the global economic agenda, sparking discussions across a number of forums. Examples of these discussions include activities conducted in the context of UNCTAD, OECD, as well as the G20. As Sarah mentioned, since late 2017, this discussion has grown in profile with the launch of an initiative among a group of WTO members on a proposed MFIF. In the WTO context, the process leading to this initiative began in early 2017 with the organization of a first informal workshop on investment facilitation by a group of countries known as the MICTA group, which includes Mexico, Indonesia, Korea, Turkey, and Australia. Subsequent informal workshops were organized that year by a group of WTO members known as the Friends of Investment Facilitation for Development, or the FIFID. At the time of the WTO's 11th Ministerial Conference in Buenos Aires, Argentina, in December 2017, 70 WTO members adopted a joint statement initiative on investment facilitation for development, where they announced plans for what they called structured discussions aimed at developing a multilateral framework on investment facilitation. As you can see on the screen, in paragraph 4 of the statement, signatories called for, I quote, beginning structured discussions with the aim of developing a multilateral framework on investment facilitation, end of quote. Based on such statements, and I quote again, the discussions shall seek to identify and develop the elements of a framework for facilitating foreign direct investments that would improve the transparency and predictability of investment measures, streamline and speed up administrative procedures and requirements, and enhance international cooperation, information sharing, the exchange of best practices, and relations with relevant stakeholders, including dispute prevention, end of quote. Ministers agreed, and this is very important, that these discussions, I quote, shall also seek to clarify the framework's relationship and interaction with existing WTO provisions, with current investment commitments among members, and with the investment facilitation work of other international organizations, and shall not address market access, investment protection, and investor-state dispute settlement. As Sarah mentioned, over the past 2 years, WTO members participating in the GSI have engaged in those structured discussions which have led to the development of the following documents. You can see on the screen a checklist of issues, a compendium of text-based examples, a working document, a streamlined text, and the consolidated text, which is currently on the table. Here, it is important to mention how the structured discussions evolved, because the participating members started with a checklist of issues under each area identified in the joint statement, which led to a checklist of over 81 issues that was completed, as you can see, in 2018. Then the next step was a compendium of text-based examples. This is important because this compendium contained investment facilitation elements that could be included in a potential framework. These examples were drawn from the Trade Facilitation Agreement, BITs, national legislation, as well as services chapters of free trade agreements, among others, and were submitted by members along with the coordinator. Then, as I already mentioned, members put together a working draft and a streamlined text and the consolidated text. I have to say that the consolidated text, same as the other text, has been circulated by the coordinator under his responsibility and is entirely bracketed. So you may ask yourselves, the ones who are not familiar to the process, what is happening in the negotiating process? Sarah already gave up an overview of what happened recently. So let's go briefly back to that. So during the stock-taking meeting at the end of last year, the group had agreed to move into a negotiating mode as of March 2020. Following the circulation of the streamlined text in January, the members had agreed to a working methodology and the schedule of meetings. But due to the COVID-19, the substantive meetings scheduled for March and April were canceled. And as we all know, also the ministerial conference. And as members awaited resumption, the coordinator circulated an informal consolidated text that I just referred to and held virtual informal meetings in June and July. As Sarah said, the group will commence negotiations in September in a hybrid format. That means in person plus virtual participants. Let's now move to the informal consolidated text. As you can see on the screen, the text contains a preamble and 9 sections. I thought that it would be useful for you to have a look at the sections, the section titles, for those of you who have not seen the text, to have an idea of the different issue areas that the framework is covering. So we have the sections on the scope and general principles, transparency, streamlining and speeding up administrative procedures, 2 rather new sections, 3Bs and 3Ter, 3Bs concerning temporary entry for investment persons, 3Ter concerning transfers and subrogation, and then section 4 on contact points and ombudspersons, 5 on SNDT, 6 cross-cutting issues, and 7 institutional arrangements and final provisions. I have inserted a list of the draft articles, which are called items currently, to provide you with an idea of the areas where disciplines are being negotiated. As you may see, the text contains areas such as a single window, good regulatory practice, in addition to the ones I have already mentioned. So here we have a broader list of issues. You can see that they range from administrative procedures to transfers, subrogation, and as I already said, domestic regulatory coherence and good regulatory practice. This is important because of the coverage of this framework, and I'm gonna develop that later on. So Sarah, I mentioned that the focus of this webinar would be on the scope and coverage of the proposed framework and its relationship and interaction with the commitments under international investment agreements. So in this presentation, I will focus on those topics. So here, what I would like to explain is that whereas the scope is contained in Article 1 of the current framework, the scope also derives from other substantive provisions in the text. For instance, Article 3.1 on publication and availability of measures, and Article 7.1 on reasonable, objective, and impartial administration of measures. I will elaborate on that in a few minutes. So let's briefly refer to the scope. As I mentioned, Section 1 contains scope and general principles. And here I put an excerpt of the current draft provision on scope. And we can see that Article 1.1 sets out the application of the framework. So I'm going to read this with you. So 1.1 sets out that this framework applies to measures adopted or maintained by members for facilitating foreign direct investments, with a footnote stating that the framework does not apply to portfolio investment, across the whole investment life cycle, including the admission, establishment, acquisition, and expansion of investments in services and non-services sectors. Later on, I will comment that members have submitted different proposals on what their understanding is about the scope and coverage of the framework. But I can already tell you that members are starting to debate over the definition of investment, the definition of FDI. Delegation has submitted a proposal on an asset-based definition of investment. So this is an interesting feature to analyze, because the footnote that you are looking at now expresses that the framework does not apply to portfolio investment, but perhaps there are other delegations which are looking for a more ambitious approach of these negotiations. So if we can then look at what is stated about what the framework shall not apply to, members have identified 3 issue areas: government procurement, public concessions, and market access and right to establish. Delegation has also proposed that the framework does not apply to subsidies. And then a very important item that is the core of our webinar today is what the framework shall not cover. And there, the proposal states that the framework shall not cover investment protection rules and investor-state dispute settlement. This part has triggered a lot of interest among negotiators, because some delegations have already suggested that there is need for more clarity concerning these provisions in order to avoid unintended consequences. And Natalie will explain to us what the consequences can be. So here you can see that there are options on the table to further clarify what the framework shall not cover. I may go a step back and say that for some academics, it is interesting to see that the text contains a proposed provision on what the framework shall not apply to, and what the framework shall not cover. So this is also something that negotiators are following. I mean, to 1.2, this framework shall not apply to, and 1.3, this framework shall not cover. So there's also a very fine distinction that negotiators are looking into. So if we go to 1.3, here we can see that there are basically two proposals which have been submitted by members in order to clarify what the framework shall not cover. And there is a very comprehensive proposal that has been submitted rather recently and that has not been the subject of a deep discussion among negotiators. These discussions are expected to take place after September, when negotiations start. So you can look at this proposal and appreciate the elements that the delegation that put it forward considers important to expressly exclude. So you can see that here, the proposal is stating that for greater certainty, this agreement shall not apply to protection of investors or investment, treatment of investors or investment, or any dispute settlement proceeding within the meaning of international investment agreements that members have concluded or will conclude. So here, this delegation is looking at the current and the future investment agreements. So this is a very important point to bear in mind for the next part of our webinar. As I mentioned briefly, even though there's a section on scope and Article 1 contains this draft, the scope also derives from other provisions, and it's important for negotiators to bear into consideration that the other provisions can broaden the scope of the framework. And an example of this is Article 3.1, which is classified under Section 2 on transparency of investment measures. And when one looks into that draft proposal, one can read the following. 3.1 states that each member shall ensure, so it has mandatory language, that laws, regulations, procedures, judicial decisions, and administrative rulings of general application, measures of general application that pertain to or affect the operation of this framework or are covered by this framework are promptly published or otherwise made available in a manner that enables interested persons and the other members to become acquainted with them. You see that there are words in brackets. As I already mentioned, the entire text is bracketed, but here the brackets note that there's still disagreement among members on the scope of these provisions. That means that members are still debating over the type of laws, regulations, and procedures that will be covered by this framework. Some members want a very ambitious approach and they want to cover measures of general application, as you can see in this bracketed text, whereas others want to specify that it would be only those which pertain to or affect the operation of this framework. This is to give an example of the many open questions that remain, not only concerning the definition of investment, or an eventual definition of investment facilitation, but also the type of measures that will be governed by this agreement. So in that for some members, it will go beyond the measures which are directly linked or affect the operation of the framework. Another example, briefly, is contained in Article 7.1. Again, because the distinction about the type of measures which will be covered has not been still agreed upon. So for some delegations, it will be all measures of general application, and for others, it will be only the ones which are covered by this framework. So this is about administration of measures. And that can include, as I already said, a broader set of measures. Another example is on reduction and simplification of administrative procedures and documentation requirements. Again, there's the same open debate. And lastly, I would like also to note that within the scope and general principles section, there is a provision on MFN. And under this provision, here the delegations are still debating over the content. And as you can see in 2.1, members are considering this text. With respect to any measure covered by this framework, each member shall accord immediately and unconditionally to investments and investors of any other member treatment no less favorable than that it accords to like investments and investors of any other country. In informal conversations with negotiators, some of them have shared concerns regarding the use of the term treatment in this context. So this aspect will be further elaborated upon by Natalie in her presentation, because the fact of including the term treatment raises a broader set of questions for consideration when it comes to the relationship and interaction of this framework with the existing web of international investment agreements. There's a 2.2, a provision that says that this framework shall not be so construed as to prevent any member from conferring or according advantages to investors of any other member and their investments in the context of a free trade area, customs union, a common market, or an economic union. There's a proposal by a member to insert a reference to other forms of economic integration. So this would be an exemption 2.2, an exemption to the MFN treatment clause. I want to note that this provision needs to be read together with Article 32.3. There's a bracketed text that states that the MFN provision in paragraph 2.1 of the framework shall not apply to the treatment accorded by a member under a bilateral or trilateral agreement in force or signed prior to X date. So these are some of the main comments I have to make on these provisions. In the interest of time, I have to stop here, but I wanted to share with you that this negotiation raises very important questions. And if I can do a brief recap, I can mention that, as I already said, the joint ministerial statement on investment facilitation called for these discussions to identify and develop the elements of a framework for, and let's bear that in mind, facilitating foreign direct investments that would achieve three objectives, which are on the screen, and I already explained. In the course of the structured discussions, the signatories have gone through different stages, from a checklist of issues and an example-based discussions, drawing, as I said, from BITs, FTAs, and the TFA, among others, to an informal consolidated text that contains provisions, a number of them of binding nature, on a broad range of issues beyond the objectives outlined in the joint ministerial statement above. So signatories have so far different and diverging approaches to several issues. For instance, the scope and coverage of the MFIF and its relationship and interaction with IIAs, which will be addressed by Natalie in the second part of this webinar. So with this, I conclude my presentation and I stand ready for your questions and comments. Thanks very much.
Thank you very much, Soledad, for providing us with this snapshot of the evolution of the discussions and this overview of the content of the informal consolidated text as it currently stands. I'd like to now hand over to Natalie, who's going to walk us through some of the key areas where the framework would overlap with investment treaty obligations and what this means. So thank you very much, Natalie.
Thank you, Sarah. And also thank you very much, Soledad, for mapping out and providing a basis to my presentation. So I'd like to give you a quick overview of my presentation today. I'd like to first give you a quick snapshot of the investment law and policy development and the landscape that we have today to put the multilateral framework that's currently in discussion into a broader context. Then I would like to move on to examine the interaction between the proposed multilateral framework and the web of investment treaties, which, as Sarah noted, is already up almost 3,000. We will then move on to the proposed investment or multilateral framework and look at how it relates to the issue of investor-state dispute settlement that most investment treaties incorporate. And there we will be looking at specifically 3 types of provisions that are typical in investment treaties. Umbrella clauses, this one is a bit less common, but also still important. The fair and equitable treatment clauses, and the most favored nation provisions in investment treaties. We will then move on to examine some of the solutions that participants to the multilateral framework discussions have put forward and have already been alluded to by Soledad to address some of the concerns relating to investor-state dispute settlement. And finally, I'll provide a quick sum up and raise some issues for further consideration. So if we look at the investment law and policy landscape, I think we can distinguish between maybe 2 types of institutions and processes. On the one hand, we have institutions that are focusing more on policy development, but also proposing reform. And the lead organization there would be UNCTAD, with also the OECD having a role in these policy developments, and also the regional economic communities who are also very active. And UNCTAD would also have a role in to some extent, coordinating and overseeing and tracking what is happening in the investment law and policy world. On the other hand, we have institutions and processes that look more at the rulemaking of international investment law. And of course, we're all aware of this web, or sometimes spaghetti bowl, sometimes noodle bowl of treaties and investment agreements that are currently in force, and how they interact and set the rule of investment law and policy. We also know, and especially right now, the rule-making bodies in terms of arbitration rules, dispute settlement, and there's some reform processes underway at UNCITRAL and ICSID. But then we have another also rule-making process institution, of course, and which is the WTO. And the WTO, so far on investment, has been the activity and rulemaking on investment has been limited to trade-related issues and in the context of services. And what's new now is that some WTO members, as we heard from Soledad, are desiring to develop rules on also investment law and investment law. And as we saw, the scope is likely going to be very broad in terms of the investment law and policy field. We have a reference to investment facilitation, but when we look at the rules that Soledad sort of showed and put up on the screen, we'll see that this is perhaps in part not what some may have expected as investment facilitation rules, because it is quite comprehensive. So this is a new player in town on investment, and it's not the WTO, but it's linked to the WTO. It came to be, it started with WTO members. And what's important here, I think, is that activities and discussions at UNCTAD in the context of investment treaties, negotiations at the bilateral or regional level, and also at UNCITRAL and ICSID, what we see is that from the governments, the people involved in those processes are investment negotiators, or maybe attorney general's offices, ministries of justice dealing with investment disputes. On the other hand, at this multilateral framework context, in that context, we have trade negotiators developing rules. And so we can see that the importance of already the policy and rulemaking that is being done by different persons in the government, and the need to understand how these interact among themselves, even more when you have different agencies in charge of negotiating rules. So what we will look at today is really we'll examine the interaction between the proposed multilateral framework and the web of IIAs. And this will require a consideration of different elements, although we will be focusing only on some of them. But when we look at the interaction, one of the main issues to think about, of course, as we heard from Soledad, is the scope of application of this new multilateral framework. We currently do not have a multilateral framework with substantive rules that overlaps or that covers investment so broadly. And so this is a very new development, and we need to keep that in mind. And depending on how the scope develops and is negotiated, the interaction will be different and more or less intense with other institutions and processes out there. Then, not only the scope of application of the multilateral framework on investment, but also the individual rules and disciplines, their content, their scope will determine the potential of conflict or overlap between different rules. And here I'm thinking, for example, a recent proposal was made by one signatory to the framework, which concerned the free transfer of capital. And of course, we know that these kinds of transfer clauses are very common in BITs. And so having the same types of clauses also in this new framework, of course, that could lead to some kind of conflict and overlap and different types of responsibilities for the governments. And then also important to consider are the nature of the rules, if they're binding or are they best endeavor rules. And when they are binding, again, the interaction will be different than if it's more about cooperation and best endeavor. Also, the composition of the membership, the treaty parties, how they overlap or not, will determine the interaction. So as we know, the multilateral framework does not comprise all governments and not even all WTO governments. So you'll have some that are in, some that are out, some that have investment treaties, BITs, with a participant or without a participant. So you'll see the different combinations, and depending on the combinations, the situation will be very different as well. The same is true, of course, for most favored nation clauses and situations when you have a multitude of agreements, and some of them are multilateral, some meaning not multilateral in the sense that it involves all WTO members, but some WTO members, what sometimes is referred to as plurilateral. And then you have a host of bilateral agreements. There again, the MFN situation gets quite murky and complex. And then finally, the issue of dispute settlement is also important when we think about the interaction between the multilateral framework and investment agreements. Because on the one hand, you'll have, if you have a dispute settlement mechanism in the multilateral framework, it will be state to state. And following the WTO approach, it will be more about seeking compliance, giving members who might be in breach time to come into compliance, etc. Whereas if you have a remedy or investor state dispute settlement, in those cases, the remedy will be different, and it will be about compensating for potential damages that the investor suffers on the one hand, plus it's not state to state, but actually investors, individual entities that bring claims against states. So that interaction is quite important, because new rules might impact how a decision is taken in the other process. But let's look at this, come back to this in a more concrete way in a few minutes. I don't think I have to spend too much time on this comparison. It's mainly to say what Soledad already explained. That on the one hand, you have the multilateral framework and the various proposals how to define its scope, and then quite a different approach in the investment agreements, where the scope is largely defined through the definition of investment. And whether it's asset-based definition or enterprise definition, the scope is largely determined by that. On the other hand, currently in the multilateral framework, we have definitions of the types of measures that are covered. Measures for facilitating FDI, or measures affecting the establishment and operation of FDI, measures affecting the authorization of investment activities. These are all different kinds of proposals that are on the table. And at the beginning, there was no definition of investment, but those things are now coming in to the discussion as well. So there's a bit of cross-fertilization from the BIT world, from the IIA world, to say, well, you can define investment as asset-based or enterprise-based, and define that to also influence the scope of the multilateral framework. And so when we think about the scope of the multilateral framework, we would look at the types of measures that are covered, and also the type of investment, how investment is defined, but also the phases that are covered of the investment. So in the multilateral framework, most of the proposals clearly say that the framework covers all phases of the investment, including the pre-establishment phase, whereas the investment treaties are a bit more unclear in that respect, and usually are understood as post-establishment treaties, unless a pre-establishment element is brought in the non-discrimination clauses, MFN, national treatment. So this is just important to keep in mind. The scope is still being determined, but whatever comes out of the scope, what is very clear is that there has never been a plurilateral or multilateral framework or agreement that has had so much overlap in terms of scope as this new framework. We'll come back to the idea that you can see that the governments were quite worried about this interaction between investment treaties, investment protection, and dispute settlement on the one hand, and the multilateral framework. And what they did at from the beginning was to say, well, this framework shall not cover investment protection or investor state dispute settlement. But what that actually means to me is entirely unclear. I don't know what it means if you say this framework doesn't cover investment protection rules. But we'll come back to that, because there have been attempts to clarify that somewhat. Now, the proposed multilateral framework and investor-state dispute settlement, most, as I mentioned, and as you all know, most investment treaties provide investor-state dispute settlement in addition to state-to-state. The proposed multilateral framework could impact those investor-state dispute settlement outcomes. And the multilateral framework, the impacts that will be most relevant will be for capital importing host states, so developing countries importing capital, for example, and especially if those countries have old-style investment treaties. In those cases, the impact of the multilateral framework on investor-state processes will be the most affected. And we'll see that in the context of a quick analysis of the umbrella clause, the fair and equitable treatment clause, and the most favored nation clause. Now, if we look at let's say an investor brings an investor-state claim based on the investment treaty's umbrella clause. First of all, let's quickly just remember what are umbrella clauses. Umbrella clauses in investment agreements aim to elevate contractual or other commitments of host states under an investment treaty's umbrella. So a typical clause would say, a broad clause, there are different versions, but a broad clause would say, each party shall observe any obligation it may have entered into with regard to investments. So the obligation or commitment that a country makes elsewhere is elevated and becomes a treaty obligation under the investment treaty. And jurisprudence varies in the interpretation of these kinds of clauses, but in general, the interpretations are very broad. So under its, and I'll just quote from one case, which says that under its ordinary meaning, the phrase any obligation refers to obligations regardless of their nature, and obligations covered by the umbrella clause are nevertheless limited by their object, which is with regard to investments. Enron, and this is from Enron versus Argentina. So the question we have to ask is whether an multilateral framework provision qualifies as an obligation under a broad umbrella clause. And that will depend in part whether it uses mandatory or hortatory language. An example of mandatory, let's look at the multilateral framework and look at an example of mandatory obligation. There is one proposal that has been made to say each member shall ensure that any criteria established by its competent authority for deciding whether or not to approve or admit a foreign investment application is clear, transparent, objective, and published beforehand. So we can see that this kind of obligation is very clear, it's mandatory, and it concerns an investment. So this kind of obligation could be brought under the realm of an investment treaty through the umbrella clause, and then we would have to conclude that some commitments under the multilateral framework could be covered by the umbrella clause, and a breach of the multilateral framework commitment could therefore be challenged in investor-state dispute settlement as a breach of the umbrella clause. Let's move on to the fair and equitable treatment clause. We are all, many of us who are working on investment treaties are very familiar with this clause, which in older treaties is very broad and vague and could read something like this. Investments made by investors of each contracting party shall be accorded fair and equitable treatment, period. These types of broad provisions are very widely used and are included in 95% of all investment treaties, and they're used in over 80% of all treaty-based ISDS cases. So they're widely used and quite successful in many instances. The interpretation of these clauses varies widely as well. But one element that has come out in many cases, in many disputes, is the concept of legitimate expectations. And that is a concept that has come to the center of many interpretations, which would mean that if the investor has a legitimate expectation of a government fulfilling its commitments, for example, then those kinds of legitimate expectations, if they're not complied with by the government, they would then lead to a breach of the fair and equitable treatment clause. What can qualify and lead to a legitimate expectation can vary, but what we know is that recent treaties try to be much more careful in the definition of fair and equitable treatment to avoid situations that would allow a too broad of an interpretation. Nevertheless, the majority of treaties still out there, and that many countries still have, are still using the old approach and the old definition of fair and equitable treatment. So coming back to the multilateral framework, then we have to ask ourselves, could a commitment that a government has taken under the multilateral framework create a legitimate expectation of an investor? And the response to that will depend on the content and also on the mandatory nature of the discipline. So let's take the example of Section 3 of the Multilateral Framework on Investment. That section concerns streamlining and speeding up of administrative procedures and requirements. And that section has very detailed rules on various issues, such as the reasonable, objective, and impartial administration of measures, reduction and simplification of administrative procedures and documentation, clear criteria for administrative procedures, authorization procedures. So you can see on the one hand, those are very specific, and the fair and equitable treatment clause is quite broad. So if an investor relies on a government's commitments under these very specific sets of rules, there is a good chance of an investor arguing that that created legitimate expectations to be treated in a specific way, to have the authorization processed speedily, to have what the government, what the investor may have found not impartial enough, that the process has to be reasonable, objective, and impartial. And of course, we would all agree that these are important or very welcome ways for the government to act. But the question is, do you want to, in case that the government is perceived as not fulfilling that high standard under the multilateral framework, do you want this to be litigated under the investor-state dispute settlement mechanism? And I think we can make the case that it could be argued that these provisions could create legitimate expectations of the investor. And in that case, if there is an investment treaty, the investor can bring a case under that investment treaty and challenge the breach of the multilateral framework and claim compensation. And then last but not least, the MFN clause. It might be, maybe Sarah, I don't know if we're running out of time. I realize that we have very little time for relatively technical issues, so I'm rushing through, and I don't know how much time I should still dedicate to this additional issue, or if you want to come back later on this one.
Natalie, I think you can continue. Yeah, we still have a bit more time. Mm-hmm.
Yes, so on this side, the most investment treaties include an MFN provision, most favored nation clause. And investors have argued in the past that host states have granted other investors more favorable treatment under third-party IIAs. So an investor would bring a claim under one treaty saying that another investment treaty provides better treatment. And investor state tribunals have allowed investors to import those more favorable provisions in the other agreement, investment treaty, to import them into the base agreement under which the dispute is brought. And so there have been importations of rights and obligations under one treaty into another treaty. These cases all concern multiple investment treaties. But in fact, you could very well argue that the same situation could occur with the multilateral framework on investment, so that if an investor brings a claim under a BIT, that an investor from a country that is not participating in the MFIF, then they could bring a case under the investment treaty against a host state member of the multilateral framework, arguing that the framework commitments lead to more favorable treatment for other investors. This is a bit, it sounds a little bit complicated, but you have to kind of visually think about the different treaties out there. Before you had different investment treaties, and now you just have another bigger pie, this multilateral framework, and the rights conferred there can also be imported into other treaties through the MFN clause in case of an investor state dispute settlement. And of course, the issue there again is, in case of investor state disputes, you can claim compensation, which isn't possible under the state-to-state mechanism that is likely to be negotiated in the multilateral framework. I'm running out of time, but I can say here there are proposals by countries trying to address this concern, that you could, how these might interact and how the multilateral framework could be used in investor state dispute settlement. And remember, we have at the multilateral investment framework, we have countries negotiating, but and investment treaties are also negotiated by countries, but the action and the disputes are brought by investors. And so there's very little control that countries can actually have over these investors. And so it's very unpredictable. And what the countries are trying to do now in the multilateral framework is to say, well, it shall not, I already mentioned, the framework shall not cover investment protection rules and investor-state dispute settlement, which I think is unclear, and which I think other countries, some countries also find unclear, which is why they proposed other language. For example, to say that this framework does not create new or modify existing rules on the protection of investment or investor-state dispute settlement. So this could fly maybe with some tribunals if they looked at it, but maybe not. It's really not entirely clear. But the case that would be brought under an investment treaty under this rule should not be modified by this multilateral framework. What this exactly means, I think, still requires more thought. Another country proposed other language to address the problem. And again, it's very much about the interpretation and the effect of the multilateral framework on other agreements. And I think there are elements in this proposal, and you can read it, it's in front of you, or read it later, that make more sense, that go into really addressing some of the problems. But again, I don't think it's clear enough to prevent some tribunals from not seeing or really just blocking off and not looking at the multilateral framework if an investor brings it into the dispute. Oops. So now, just to sum up, this was quite a complex discussion. I was struggling in the middle a little bit because it was getting a little bit technical, and I was trying to go fast. But I just want to make 3 points here. First of all, that the future of international investment law and policy development and the potential fragmentation of the international regime really requires further discussion. Because here you're trying to ring fence or shield, one regime or one treaty from another treaty, but in the end, the government is bound by the multitude of treaties and obligations and rules, and it will get harder and harder to start trying to isolate the different rules that countries adopt in one space and then the other space, and are negotiated by one ministry and then the other ministry, and how they have to coordinate. The fragmentation is a real challenge, and I don't think it can be overlooked, and needs to be discussed and analyzed further. Second, the participants in this structured discussion on investment facilitation, as we saw, they're still in process of defining the scope and content and also the nature of the disciplines. I think that right now, a lot of the elements, as we saw from Soledad, come from different chapters of trade agreements and so forth. And it looks very different from for example, what Brazil has been doing in its investment treaties, which focus very much on investment facilitation. It has a lot of different elements that countries still need to analyze. And in that process of analysis, they need to also see the interrelationship with other bodies of law. And finally, as we saw, the multilateral framework could really significantly impact the investor-state dispute settlement initiated under investment treaties. And further discussion is needed as to the type of action that countries have to take to avoid unintended consequences with respect to investor-state dispute settlement. So thanks a lot, Sarah, for allowing me to keep going.
Yes, thank you very much, Natalie. So we'll move on quite quickly now to make the most of our remaining time, and I'd like to turn to our expert commentators. I'll start with you, Chantal. So for those who missed the introduction earlier, we have with us Chantal Onanaiwu, who's the Trade Policy and Legal Specialist at CARICOM. Chantal, what is your assessment of this topic that Natalie just presented on, so the interrelationship between international investment agreements and the current version of the draft framework? And in light of that, what are the main challenges in your view, and how could developing countries start to think about addressing these challenges?
Thank you, Sarah, and good morning or good afternoon to everyone. I'd really like to thank the IISD for putting together this very timely webinar. It's important that it's taking place, this discussion is taking place at this time, not only because it will be picked up, as you mentioned earlier, at the upcoming forum, but because negotiations on this framework are scheduled to commence next month. And this is an important issue for the region that I represent, not only because 4 CARICOM countries are participating in this joint statement initiative, but because the community has taken a decision to monitor very closely these discussions because of the appreciation of the implications that they may have. And I'm really heartened to see that there are a number of participants from CARICOM attending this webinar right now. But to pick up more specifically on the questions that you posed, there is a clear interrelationship between the existing stock of international investment agreements and the multilateral framework on investment facilitation being developed. And I think apart from picking up this relationship from the content of the text, the discussions have made it clear that participants in the JSI are very sensitive to this issue. You see it not only in the proposals that they have been more recently featuring, but also in the discussions on those proposals, observations that are being made. There is a sensitivity to the interaction between these agreements, the need to insulate one legal regime from the other. You see references to proposals like mutual exclusion clauses and insulation provisions, which underscores the point that Natalie made, that there is an attempt to try and ring fence the 2 regimes. But of course, the reason we're having this discussion is because of our acute awareness that notwithstanding what may be placed in the MFIF to do so, it may not suffice in all cases to preclude investors from bringing claims that are seeking to import these obligations into the investment treaties. And more importantly, it may not preclude arbitral tribunals from being persuaded that the provisions can be imported. Natalie would have highlighted, or I think, no, it was Soledad, I think, that pointed out something very striking about the current text, which is that even though from the outset, the participants made it clear that they did not really intend to venture into the substantive realm of investment treaties through investment protection rules and investment liberalization or investor-state dispute settlement, that some of the elements that you see in the current text, like proposals on free transfer of funds or subrogation, which you would normally associate with the standard investment standard investment treaty laying down standards of protection, are featuring in this framework. And, you know, sometimes the proponents are at great pains to explain how those components fit quite neatly into a framework dealing solely with investment facilitation. I wanted to just touch on some of the points that Natalie made. I'll start first with the 3 conduits, if you wish, through which obligations in the multilateral framework might find themselves into investment treaties. And I think Natalie is right to zone in on those 3 components. If most countries with investment treaties, particularly older generation treaties, actually take a look at their content, they're actually going to find many of the elements that she described featuring in them. CARICOM countries last year engaged in a forum on international investment agreements. It was an attempt for officials to take stock of their existing treaties and the content of them. And it was discovered that 40% of these treaties have umbrella clauses in them. Some of them are very, very broadly worded. And I think the fact that the importation of WTO obligations into investment treaties via an umbrella clause is untested to date shouldn't really give us comfort, because we have not had to date a framework with this kind of scope and coverage with respect to investment. And so it shouldn't surprise us that the issue has not necessarily arisen. But I think there is a significant prospect of something like that arising, a claim like that arising, because of the broad, potentially broad scope of coverage of the multilateral framework on investment. And because, as Natalie mentioned, there are concrete, hard obligations which may be of interest to investors, which are featuring in the multilateral framework. I mean, one may think at first, well, why would an investor have any interest in bringing a claim with a view to seeking compensation that essentially good governance type provisions, which is how these provisions are often framed, have been breached. But when you look at the nitty-gritty of some of the obligations, it's not far-fetched to see why there might be interest why an investor may have interest in actually using ISDS to challenge whether or not the state has honored these obligations. When you think of the fact that some of these obligations being discussed relate to matters like the timely processing of applications for an authorization to invest. They relate to whether the measures whether the administration of measures by the state has been reasonable, objective, and impartial. They relate to whether procedures are unduly burdensome and whether they could be simplified. One could see how an investor may have an interest in actually using investor-state dispute settlement to challenge whether the state has actually honored these obligations. Now, with respect to the fair and equitable treatment standard, all I wanted to add to what Natalie would have mentioned is that even where there have been attempts in more recent treaties to circumscribe the scope of this standard, we still are not clear on whether those attempts would successfully preclude an investor from importing the elements of the multilateral framework into an investment treaty. For instance, some agreements that elaborate the minimum standard of treatment as opposed to, say, using the term fair and equitable treatment, they seek to clarify that a breach of a separate international agreement may not necessarily constitute a breach of the provision in the investment treaty. But again, while that may provide some comfort, we're not altogether clear that arbitral tribunals would be persuaded by that clarification. Some investment treaties try to specify the content of the fair and equitable treatment standard. Again, it's not clear whether even where the content is specified, a tribunal may not be persuaded to look at whether honoring the commitments or a failure to honor the commitments under the multilateral framework actually constitutes a breach of the content of the standard which has been specified. With respect to the MFN clause, I just wanted to make a couple of observations. One, again, there have been attempts in some recent treaties to circumscribe the scope of the MFN clause through, for instance, non-importation clarifications. You know, this provision, clarifying that the provision is not intended to be used or seeking to preclude the importation of provisions from other treaties. I guess maybe the attempt there is to focus the MFN provision on arguably what it was originally intended to focus on, which is whether there has been some distortion of conditions of competition between investors in the marketplace, as opposed to whether more favorable treaty provisions in agreements with third countries exist. Again, we're not quite clear on whether these non-importation clauses will be adequate. Some of them are more focused on not importing procedural elements from other treaties. Some of them don't specify that what is excluded is importation of substantive obligations. That's one point. Also, even in the joint statement initiative discussions, proponents of some of the clarifications that Natalie would have mentioned have actually highlighted that, some of these non-importation clauses don't exist in the older generation agreements, and to buttress their desire to have ring fencing or insulation between the two regimes, they've actually even pointed out that some of the older generation treaties have non-derogation clauses that seek to clarify that even with respect to existing or future international obligations between the contracting parties, there should be no attempt to preclude the application of the more favorable of the obligations that exist between the parties. So what I just wanted to just affirm through my initial observation is that there is significant scope for interaction and overlap between these two regimes, and that is evidenced in my mind most strikingly by the attempts that participants in this initiative are making to ring fence the two regimes, because they do appreciate the risks of importation of the multilateral framework elements into IIAs through ISDS. As Natalie mentioned, it's unclear whether the attempts to do so will be successful in all cases. I just wanted to switch to the second part of the question that you posed to me, Sarah, which is more about, well, how do developing countries deal with these challenges? Maybe you can let me know how much time I have to do so.
Sure. Just a couple of minutes would be great, so that we can hear from Hamid as well. But thank you so much.
That's fine. And I want to make 2 points in the couple of minutes I have. The first is that one of the most important actions that developing countries need to undertake is they have to pay close attention to these discussions, even if they have not opted to formally join the discussions. They need to understand the implications of this developing framework for them. For sure, the countries that have decided to participate need to be active participants. They need to engage. They need to be clear on what the proposals are, be clear on what the implications are, ask themselves questions that I suspect Hamid will address in his comments about, the contribution that the framework may ultimately make to their sustainable development goals. The second point that I quickly wanted to make is that countries need to review with urgency their existing stock of treaties. This is an imperative not just because of the importance of understanding the interaction of this developing framework with their existing stock of treaties, but because countries need to understand the extent of the risks that they may be exposed to under their existing stock of treaties. This was the focus of the forum that I mentioned that was held by CARICOM countries last year. The reality is the extent of exposure may vary. Some countries may not even have any investment treaties in force, which is the case of some CARICOM countries. Some have a more developed network, and they need to understand the risks, the extent of the risk that these agreements pose, and then in light of that assessment, they need to make concrete decisions and choices about reform of those treaties, whether it's renegotiation of them or termination of them or other options. I'll stop here.
We really appreciate your insights. And it was interesting to see you picked up on the importance of paying close attention to these discussions, which I think sort of echoes a comment that we had in the chat from Moataz Hussein as well. So thank you so much. I'd like to turn now to Hamid Al-Qadi from UNCTAD. Hamid, UNCTAD has worked extensively on investment for sustainable development. In your view, how does this draft framework fit into the broader landscape of international investment law and policy for sustainable development? Thank you.
Thank you very much, Sarah. I would like to start by thanking the IISD for inviting me and UNCTAD. Thank you, Natalie, Soledad, and Sarah, very much for your great work. I think this is, as was said earlier, a very timely meeting because it highlights key points that will basically provide countries and negotiators with the awareness and the tools needed for the negotiations of this important framework. I will be very brief to reassure the attendees up front. Very brief. I only have 4 points that I will mention briefly. The first point is context, then development angle, priorities for developing countries, and broad interpretations. I think the context, Natalie mentioned the context, the international context, but I also would like to mention the commitments that developing countries already have, not only with regards to international investment agreements, but we all know that developing countries already have massive investment promotion structures and rules, investment facilitation, one-stop shops, national investment laws and regulations. Actually, developing countries, according to our research and databases, developing countries have much more than developed countries in terms of investment laws, regulation, incentives, facilitation measures already in existence domestically. Adding to that, there are the state contracts as well, contracts between a ministry and a foreign investor. This is in addition, of course, to the famous 3,000 investment treaties and the FTAs. So this discussion does not actually fill a vacuum. This framework of investment facilitation should be seen as coming on top of a very complex legal framework for investment, a very complex network of commitments that developing countries have. This is the first point. The second point is the development angle. The initiative is called Investment Facilitation for Development. What we developing countries should be careful about is that this development angle is not only in the title, but it is actually reflected in the main text very clearly in the key provisions. That in itself will create an additional challenge, because are we going to provide investment facilitation measures only to those investments that contribute to development? Are we not going to give the same investment facilitation measures to other investors? Is there clarity with this point? Is this a kind of discrimination? These points need to be clarified. Also, development itself needs to be kind of defined with specific criteria. Number one, we need to define investment, and I think in the first presentation, Soledad gave us some examples, but we need to define investment in very clear terms. Investment, and making sure that we are talking about investment that contributes to development or to sustainable development, and clear indicator of what is development, and clear picture of what kind of investment project will be covered, will gain these facilitation measures, and what will not. What we need to avoid is the argument that automatically any investment is good for development, therefore it covers all kinds of investment. Because then the title is meaningless and should be investment facilitation, full stop. That's, I think, an important point. The third point is priority. Now is really, countries need to think and prioritize what needs to be done. The first thing to do, I think there are things that are seemingly or actually factually more urgent than a multilateral investment facilitation framework. There are important legally binding investment treaties that are resulting in investor-state dispute cases, costing real money that goes to compensation, sometimes compensation for actions that are legitimate by the state. It's not always the case, but there is a big chunk of cases where the action by the government was a legitimate action for the protection of the public interest. Isn't this an urgent case? Now this investment facilitation initiative costs money. I mean, it used to cost money, travel, cost energy, cost focus, costs a lot of effort, but there is other also urgent issues that developing countries need to consider. I think Chantal made this point also in her concluding remarks, and I fully agree, especially today, when we know that measures implemented for mitigating the risk of COVID-19, we know that they can result in friction with IIAs and ISDS cases. Finally, the broad interpretation. I think here we need to also learn from the past, and negotiators need to keep in mind that whatever they agree on paper, it can be very beautiful, very nice, nicely drafted. But at the end of the day, the broad interpretation of third parties who are not involved in the negotiations can sometimes be very broad. They can interpret a simple facilitation measure that is written black on white in the treaty or framework as such. They can interpret it instead of A, they can interpret it as A, B, C, D, E, F, G, until Z. And we have seen that happening time and time again in investment treaties. The last point is, I think that, I think just to put it simply, is that maybe countries can be successful in excluding investment protection and ISDS from the investment facilitation framework. That's an objective that I think can be achieved. But what we don't know, and what is probably not possible to achieve, is to ensure that IIA interpretations will exclude IF investment facilitation commitments. So we can exclude all we want, but what we need is, what we cannot ensure is that the IIA will exclude investment facilitation. Again, now my conclusion goes in the same direction as the conclusion, I think, of Chantal and also of the other speakers, is that the urgent need is really to tackle your existing stock of IIAs that are really acting like a straitjacket. You see, acting like a straitjacket in different ways. Acting like a straitjacket when you are trying to protect public health, when you are trying to regulate in the public interest, and also acting as a straitjacket when we are discussing a new, fresh, multilateral effort for investment facilitation. I think I can stop here and then allow time if there are discussions by the attendees. Thank you very much, Sarah.
Thank you so much, Hamed. And particularly, I think the point of the importance of ensuring that the development angle is not reflected only in the name of this framework, but throughout, and of defining investment with reference to development. So I might just give an opportunity to Soledad and Natalie, who've been answering some questions in the Q&A chat box, if there were any points that you wanted to sort of pick out and share verbally for the benefit of those listening to the interpretation, please do come in. In the meantime, I did want to turn to a question that we received in advance of the webinar via email. from Rafael from Brazil, who I can see is here with us. I should just quickly pause and say we are at the end of the allotted time, so if you do need to move on to other commitments, we will of course understand, and thank you so much for your attention already. But for those who are able to stay for some Q&A. So the question from Rafael was, how would the exceptions in the MFN clause found in some investment treaties that excludes the application of MFN from treatment provided through a free trade area or a customs union, how would this type of exception apply in the context of the multilateral framework? So Natalie, I might turn over to you to answer this question, please.
Thank you, Sarah and Rafael also. It's, in my view, so most investment treaties do have carve-outs for the MFN clause with respect to regional trade agreements and integration agreements. Sometimes they go beyond that. So for example, some of the Canadian agreements really extend to other international agreements and can be more broadly formulated. But I think if the most frequent, which really only refers to regional trade or economic integration agreements, I think it would be hard to argue that the multilateral framework is such an agreement, which means that under most treaties, you wouldn't have that exclusion. And just one more thing, the more recent agreements, they specifically, as Chantal also mentioned, have other types of exclusions or address the issue of importation of substantive and procedural provisions from other agreements in different ways, not a proper just carve out, but in different formulations. But that is still only in the recent agreements. So I would say you will find some recent agreements that would have a proper carve out, which would include MFIF, but most agreements would only refer to these traditional carve outs, and I think they would not qualify. I don't know if somebody has a different view, expert view, then should just come in and debunk and respond to that. But that's a little bit how I read it. Thank you.
Thank you for that, Natalie. Were any of the other expert panelists interested to come in on this question or to pick up on any of the other questions that have come through in the Q&A chat box, which have been answered in writing, but if there were any points there that anyone wanted to pick up on, you're more than welcome to in the final minutes before we close. We already appreciate having had an hour and a half of everyone's attention for such a long time. So were there any other points anyone would like to say? Chantal, I can see you unmuted.
Thanks. I just wanted to briefly comment on one of the questions, which I think was trying to get at how the kinds of provisions on transparency and good governance in the multilateral framework on investment compare to existing investment agreements. And that was actually a point I had wanted to quickly touch on, because in essence, many, and UNCTAD has published analysis on this, but many of the many existing international investment agreements don't have concrete investment facilitation measures in them. There may be some transparency, broad transparency related obligations, nothing as prescriptive as what's being developed in the multilateral framework. There may be some obligations as well that relate to facilitation of the entry of investment related personnel in some agreements as well. Natalie mentioned exceptions to that, such as Brazil's cooperation and facilitation of investment agreements, which do set out more concrete types of measures that can be taken to facilitate investment, and some of which feature in the elements that Soledad would have outlined. So I wanted to pick up on that because I think that the absence of these types of measures from existing, many existing investment agreements speaks to the interest that investors may have in trying to import some of these elements, which frankly don't regularly feature in many investment treaties into those regimes. I gave examples of some, but the short answer is many of these elements, these concrete investment facilitation elements that largely relate to transparency and efficiency of administrative measures and procedures, they don't often feature in the same way in many investment treaties.
Yeah, thank you very much for that, Chantal. There was just one other question I might sort of throw open to see if anyone would like to have a go at answering, and it comes from Joel Richards, asking about, or sort of echoing the concern around fragmentation that was raised by the panelists, and asking about a potential solution being a sort of grandfathering provision where the framework would not apply to existing agreements. It would only apply to new agreements concluded afterwards, either sort of in perpetuity forever or for a set period. So I wanted to know if any of the panelists had a view on this as a potential solution, and how that might affect treaty making going forward. Did anyone have a view on this? We could either share some comments now, or we could take this offline and respond in writing after a moment of reflection. Natalie.
I guess the question is, does it mean, you know, I'm not entirely clear, but would it mean that for future agreements you would allow that interaction, and for past agreements you wouldn't? If is that how you described it? I think the issue there is, you know, what countries are really worried about is arbitration. They're not worried about trying to improve their systems. They're worried about, you know, first of all, having everything mandatory is already an issue. So you'll see in the bracketed languages very different approaches. Sometimes, you know, Brazil's sort of treaties often refer to subject to domestic law. So it's more about how things are applied, but they don't prescribe how you design your administrative systems. It's more how you use them according to your law, etc. So one is, you know, how, if you have mandatory rules, which is already not agreed to by everybody, do you want to subject it and to investor-state dispute settlement so that it's no longer state-to-state? And of course, you can't really control what an investor does. And then in addition, do you want to, if you're having issues in the way you, you know, you're maybe in a transition and you have some delays in your administrative processes of permitting or authorizations, do you want to be held liable in such a way that you have to pay compensation with a tribunal deciding whether, you know, the investor was somehow harmed through the delay, and then you have to pay compensation, or that it missed maybe another investment opportunity because it was waiting too long? I mean, I'm not saying that would be a good thing to wait too long, but the question is, do you want does the government agree to be subject to outside arbitration plus compensation? And therefore, I think that it would be hard even for governments for future agreements to say, well, you know, then that you only grandfather the past but not the future, if I understood correctly.
Thank you very much, Natalie. I think we're going to need to close now. We've gone over by about 13 minutes. So I will just wrap up by saying thank you so much to our panel, our expert commentators, Chantal and Hamid, for joining us, for Natalie presentations, and to everyone who has joined us for this discussion, who's asked questions and made comments in the chat. We really appreciate your time, and thank you also to our interpreters. So we hope you all enjoy the rest of your day and that you join us again for the next webinar in our Investment Law and Policy webinar series. Thank you very much. Bye-bye.